Barb, my friend, we did talk about this trial as it was leading up to yesterday's verdict. Your reaction, because I think that the table was already set for Trump to lose, partially because of who he is, his nature, but also because there were some legal decisions that went into this trial that precluded Donald Trump from being able to argue in any capacity that he had liability for this defamation.
Well, that's right, Katie. The judge here ruled that the prior jury has already decided that Donald Trump did indeed sexually assault E. Jean Carroll, famed E. Jean. So this case was really all about just damages for his subsequent statements that were defamatory to her. But in some ways, it was expected, of course, there would be liability. And the question really was how much. But I do think that this is a big deal. It's a big victory, not just for E. Jean Carroll, but for the rule of law. I think one of the things Donald Trump tries to demonstrate is that he's above the law. The continual posts on social media, even during the trial, I think was an effort to say, you can't touch me. And by sending a verdict of $83 million with $65 million in punitive damages, that's damages designed to punish. I think this jury gave a very loud response rejecting that view of Donald Trump and Trumpism.
Barb, you and I have tried cases throughout the span of our careers, and you and I both know jury selection is actually the most important part of any jury trial. Of course, there can be drama in closing arguments. There can be maybe a Perry Mason moment during cross-examination, but really it's the selection process of jurors that our viewers need to understand is the critical moment when the future of that trial is really laid out. Talk about what you think were the most impactful moments or the elements that you think that this 9-person jury considered. And I'll remind our viewers that there were 7 men and 2 women that served on this particular jury.
Yes, and really the goal, Katie, is not to stack the deck because the other side is there selecting as well, but just to find people who will be fair-minded to your case. That was the goal that Roberta Kaplan had in mind. That is the goal. And it appears that she succeeded in getting people. So, some people say, well, you need women on the jury in certain cases or men on the jury in certain cases. But here, regardless of gender, this is really about can you have fair-minded people here. But I think there were some key moments in this case. And in many ways, Donald Trump was his own worst enemy. So when he testified, all he did was get on the stand and say he stands by everything he said in his deposition. I suppose that gave his lawyer an opportunity to then argue things that were contained within his deposition. But then when he tried to testify further, he violated the rules that Judge Kaplan had set forth here, which was all about sticking to what the relevant issues were in this case, not liability, simply damages, and he couldn't do that, so he got off the stand. But I think going back to the idea he's his own worst enemy, his testimony was not helpful. His position in the New York fraud case, bragging about the value of his assets and how much money he has, I think hurt his case. His continual posts on social media throughout this case, continuing to defame E. Jean Carroll, I think hurt his case. And then in closing argument, while E. Jean Carroll's lawyer was arguing to the jury, Donald Trump stood up and walked out, again, demonstrating that he is not viewing this as something that should subject him to the rule of law, should show any remorse. And I think all of those things contributed to the verdict that this jury returned.
A large part of the conversation, now that the verdict has been rendered, Barb, is when will E. Jean Carroll ever see any of this money? We do know that an appeal was filed by Donald Trump on the first verdict from her first defamation trial, and Donald Trump has pledged very loudly that he's going to appeal this verdict. Talk a little bit, Barb, about timing. We can't really call when an appeals court's going to be able to move and how quickly it'll happen. As we know, we've been waiting for that presidential immunity appeal decision to come out from the D.C. Circuit. But talk a little bit about timing in terms of when E. Jean Carroll might actually see some of the money in this case.
Well, Donald Trump will have to file an appeal within 10 days. We'll know that he's interested in an appeal. And then he also will have to put up some sort of an appeal bond. And the idea of an appeal bond is you have to put up money so that it is to discourage people from filing frivolous appeals just to delay the day of payment. Sometimes it's the full amount or more than the full amount of damages. When the damages amount, though, is this high, $83 million, it may be that something less of that amount will be acceptable. But then, appeals work their way through the appellate courts. It is not unusual to take many, many months, if not years, to have a decision work its way all the way through the appellate courts. So in terms of when E. Jean Carroll actually gets her money, I don't think it'll be in calendar 2024. Could be in calendar 2025. I imagine one of the issues that the Trump team will raise on appeal is that $83 million was too much. But I think they made a good record about why this number was what it is. And even if that number gets reduced, I don't see it getting reduced substantially.
Yeah, and Barb, I got less than a minute, but I want to kind of emphasize something you just said about the appeal and the record on appeal. We did see lawyering that came out of the defense team with Alina Habba. By all accounts, from reading the transcript and following what happened in that trial, there was a failure to preserve the record on appeal by way of objections that didn't happen or were improper, etc. Talk quickly, Barb, about how important it is to have a skilled trial lawyer when you're in trial versus somebody who perhaps is a skilled mouthpiece only.
Yeah, so the standard on appeal is very different if you preserved an objection on the record in the trial court. And there were notable moments when Alina Habba failed to do that. And so if you fail to note it and you bring it up on appeal later, you are bound by a very different standard, a clear error standard under the appellate record. And so it can be very damaging to someone's case when you have a lawyer fail to object at the moment it happens in the trial. The purpose of that rule is to avoid sandbagging, so that if you could have corrected the record now, you should do that. Her failure to do that could ultimately mean another loss on appeal.